Good morning, everyone. Can everyone hear me now back? Good. Still the same guy nodding his head. Thanks very much. Ladies and gentlemen, I'm Quintin, an attorney and lecturer from the University of the Free State in South Africa. Today I'm quickly going to be talking about the role and effect of social media in the modern workplace. Very broad aspect to cover in just one article, I should say. But ladies and gentlemen, social media is a global phenomenon. Social and electronic media. It plays a part in our daily lives in almost every aspect. And the same is true when it comes to labor relations. It's so important and such a global phenomenon that it has become sort of a bad thing to a certain extent, in the sense that you can't even name your pet rhino anymore without it being blasted all over the internet. I'm just kidding, we don't have pet rhinos in South Africa. We have lions. All right, now the quote there above, businesses need to fully transform to properly address the impact and demands of social media, probably sums up the issue. The issue best. Social media and electronic media, ladies and gentlemen, in the labor relations is largely unregulated, and it's this unregulated sense or unregulated nature thereof that creates a lot of complex questions in labor relations. Questions related to privacy, defamation, the question of whether there are any constitutional rights that are infringed upon when an employee posts certain information or certain comments on a Facebook site. Some of the questions facing the labor law in the workplace itself is, can an employee disclose work-related information online, and can an employee use information about an applicant that was retrieved from a social media platform? Now, apart from these issues, there are certain advantages to social media and electronic media that we will take a look at a little bit later. These include the fact that you can use electronic and social media as a good marketing platform, or your communications platform, communication between the workplace and between the workplace and clients, and between the employer and these employees. It can also be used in collective bargaining. I'll explain to you exactly how that works a bit later on. And also in terms of employment contracts, creating and terminating employment contracts. These two cases, Jafta versus Ezemvelo KZN Wildlife, you don't have to remember these South African sites, fortunately for you. These cases have decided concurrently that labor contracts can be created and terminated through the use of electronic media. In these cases, through SMS messages. So you might be wondering, all right, fine. Social media and electronic media exists. It's used in the workplace. So what? Why should it be regulated? What's the big whoop? Well, a few years ago, there was a survey in the American universities done from at least 3,000 students and young professionals, and it found that at least half of these young professionals and students would not accept employment in a workplace where the workplace bans or restricts the use of electronic and social media in that specific workplace. Or they said that, yes, fine, we'll accept employment, but if you take a look there at the bottom, we'll try to find a way to bypass the restriction or the ban. Now, that's throwing a spanner in the works of a healthy labor relationship in the workplace, if there ever was one. The fact, ladies and gentlemen, is that without proper regulation of social and electronic media in the workplace, employees will continue to spend valuable working hours online, updating their statuses or chatting to friends or seeing what the wife's up to, and so on and so forth. So the question really is to find the balance between the rights of the employees on the one side and the needs of the employer on the other side. The whole question about overregulation or underregulation when it comes to social media and the use of electronic media. Now, social media and information used on an electronic platform is considered to be indirect communication in terms of the South African Regulation of Interception and Communications Act, as a much wider name, but for now we'll stick with RICA. This specific act, ladies and gentlemen, limits the flow and use of information electronically online, especially in the workplace as well. I should probably just mention on this point that RICA is a very controversial act in South Africa. The two sections that I mentioned there on the slide, Section 30 and Section 40, created a lot of problems a few years ago. These sections state that all telecommunications service providers must gather all the personal information of all their clients, and this includes your full name, your identification number, what your salary is per month. Yes, it even goes that far, and so on and so forth. A lot of personal information that you have to share with your telecommunications service provider in order for you to actually be able to use your phone. They won't activate your SIM card, so you can't use your phone if you don't divulge this information. Now, the purpose of divulging this information is so that government, in terms of Section 30, will have an easy access to intercept your communications if you're considered a threat to the country or a threat to law as such. So you can think it's a very controversial act. Now, this form of indirect communication, ladies and gentlemen, is readily and easily available in the workplace, which has prompted employers to institute workplace policies, and the restricted access protocols in the workplace are trying to ban and limit and restrict the use of social media in the workplace. But what are the problems when it comes to this sort of restriction? There's a possible negative effect on the employment relationship in the sense that employees, then morale is negatively affected by seeing all of these restrictions. You're not allowed to do this, you're not allowed to go there, you're not allowed to do your shopping while you're just waiting for this app to be loaded on your screen or anything in that regard. So this can actually prompt them or force them to find ways to move across, to move beyond the ban that you've placed in your workplace. Problems with the enforcement, ladies and gentlemen. How do you enforce the workplace policy, all these restricted access protocols on the smartphones of your employees? It's not the employer's property, which means that the employees will have a reasonable expectation that all information gathered and stored on their own personal smartphone would have some sort of security or will have the right to privacy on that sort of information, which is not always the case. So they can spend hours and even years, perhaps, online doing nothing apart from working. Social media is about sociology, and psychology more than technology. Now, this quote, ladies and gentlemen, emphasizes how employees, as all human beings, have an integral need to interact with people of more or less, or in the same situation. Employees have that same need. The problem is that social media and electronic media gives easy and readily available access to this, to fulfill this specific need, and it can become an addiction in the workplace. And it can certainly decrease productivity in the workplace as well. So, what does the law say regarding this? Well, the United States National Labor Relations Board admits that social media is an integral part of the workplace as such. It can, to a certain extent, be seen as the new-aged water cooler, because it finds that the use of social media between employees is regarded, or can be regarded, as a concerted activity, which is a right that every employee has to act together with other employees to improve their working terms and conditions in terms of Section 7 of the National Labor Relations Act of America. Now, with regards to advantages of social media and electronic media in the workplace, so we can cover that, get that out of the way. Marketing. A lot of companies can use electronic and social media in marketing. It's the easiest way of advertising your company. But when small businesses, or businesses as such, try to use these specific platforms as a marketing tool, they should also always remember that they need to understand the culture and the nature of the market that they're trying to target, so that their marketing strategies are not regarded as spam or unsolicited messages, which in some countries are illegal messages. Communication, it is a cheap and instant form of communication between the workplace and clients, between the employees themselves, between the employees and the employer. And in collective bargaining and dispute resolution, it can also play a valuable part as well. There are certain companies that have already designed controlled websites to inform their employees what the status is of a collective bargaining process or a dispute resolution that might exist in the workplace. This certainly eliminates any false information that might be spread by any anti-competitive trade unions in the specific market. A good example of this, I don't know how many of you have heard of the Marikana massacre last year that happened in South Africa. Unfortunately, it was a poor communication between the trade unions and the employees, and when collective bargaining between the mining bosses and the trade unions failed, employees went on an unprotected strike. They were not communicated, they had no communication with regards to what was said during collective bargaining, what they decided, what they didn't decide, what offers were laid on the table, which weren't. So they went on an unprotected strike, which later on changed into a complete and utter farce when the police got involved, and unfortunately a lot of miners lost their lives during that whole protest. It is utterly impractical for the employer to expect to completely restrict or ban the use of social and electronic media in the workplace, ladies and gentlemen, considering that the majority of today's prospective employees have grown up with electronic media in the workplace. They've grown up with social media, electronic media, the flow of information, the access and the use of information. To take it away from them would be impractical. They will always try to find a way to get back to their social media site, their daily addiction in the workplace. Yes, I'm here at work at 8 o'clock, logging onto Facebook. At work. The risks involved when it comes to, the risk involved when it comes to the use of electronic and social media, ladies and gentlemen. Let's start at the bottom there. Any conduct on the part of the employees that can defame the good name of the employer or of the workplace. This includes online defamation and the divulgence of confidential information. And on that point, it doesn't matter whether it's intentional or negligent posts, online defamation posts, you can be held liable for it, and it can lead to disciplinary action. In South Africa, we use the multiple publication rule. You don't. In the United States of America, the single publication rule is used, as I understand it, which means, ladies and gentlemen, that with regards to online defamation, one employee is a disgruntled employee. The employer didn't like what she wore the specific day, so she went on Facebook and said he looks like a pig today, or anything in that regard. Now, every copy of that post, from Facebook to Twitter to Yahoo to any other electronic media site, every one of those posts can give rise to another cause of action in South Africa. In America, that rule does not apply, fortunately. I think your system in that regard is much better than ours. And then lastly, ladies and gentlemen, probably the most obvious risk when it comes to use of electronic and social media in the workplace is a decline in productivity, like I've already mentioned. Now, I know that this specific person does not have a computer there on his desk, but that is a South African version of Facebook. Privacy is dead and social media holds a smoking gun. So employment, ladies and gentlemen, when it comes to the privacy of personal information, especially with regards to the employees, can their online activity be intercepted and monitored by the employer, but more importantly, can it be used by the employer during the employment stage to decide whether he wants to appoint this person in the job or in the vacant position or not? And does the right to privacy play any part in this regard? Well, the South African Constitution, much like your Fourth Amendment to your Constitution, guarantees the right to privacy. In the South African Constitution, it goes so far as to say that this includes the right not to have the privacy of their communications infringed upon. We have a limitation clause in our Constitution with regards to all of the rights that are named in the Bill of Rights. The limitation clause is Section 36. It states that any piece of national legislation that is reasonable and that limits the right still within the ambit and within the scope and the ideals of the Constitution. If there's a limitation that exists in a national piece of legislation like that, then it would be allowed, but it can still be tested in the Constitutional Court, whether it is constitutional or not. Now, America in 1998 went into an agreement with the European Union called the Safe Harbor Agreement. Now, this is largely based on and complies with the Organization for Economic Cooperation and Development, the OECD's guidelines on the protection of privacy. Now, this states that any organization that wishes to obtain and use personal information of employees, basically, ladies and gentlemen, must comply with the following requirements. First and foremost, they must give notice with regards to the collection of this data and the purpose for which this data is collected and who they will be sharing this data with. The employees must be given a choice to opt out in the sense or in the situation where this specific organization wants to share the personal information with third parties or use it for a purpose other than the purpose for which it was originally collected. The onward transfer to third parties can only happen if that third party is also a party to the Safe Harbor Agreement. Employees must be given access to the information so they can change it if it isn't 100% correct. This is where data integrity also comes in. The data that is collected must always be reliable and accurate as well. There must be security precautions to ensure this information does not get misused or get lost or damaged in any way, and enforcement of these specific policies, the policies of the Safe Harbor Agreement. The companies must be monitored as well. In this regard, a teacher from Michigan was suspended because she refused to give her employer her Facebook username and password. This after there was allegations that she posted rather obscene pictures on Facebook. It wasn't obscene, it was pictures of her legs, for heaven's sake. Nonetheless, in South Africa, this kind of request or the use and access to this specific information can infringe the provisions of our Employment Equity Act, which states in Section 6, if you can follow me there, employers cannot unfairly discriminate against employees or applicants for employment on any one or more of the following listed grounds, which includes race, gender, political opinion, religion, sexual orientation, HIV status, pregnancy, and similar grounds. So, if an employer decides not to appoint an employee, and it turns out this specific person actually did a little bit of research on Facebook or on Twitter, how can we be sure that the reason why he's not appointing this person was not because of the political views or sexual orientation that he found on that specific media platform? Sorry, I'm like a weatherman already here. Could the procurement and use of this information constitute a breach of the employee's rights? Basically, the right to privacy. The Constitutional Court of South Africa says yes, but one has to take into consideration a few factors here. If the manner is too intrusive, the manner in which the information was collected, if it's too intrusive, it could be an infringement of the right. It's all the prima facie infringement of the specific right. There are still a few other tests to run. The nature of the information, if the information that is collected has no reasonable bearing on the employment relationship, and that is very important, that's why it's underlined, because I will be explaining that a bit later on as well. If it has no reasonable bearing on the employment relationship, then the information is recruited for what reason exactly? It could be an infringement of a person's constitutional right. The purpose for which the information was originally collected, if it isn't used for that purpose, then it could be an infringement, and the nature of dissemination. If it's communicated to the press in any way or to any third party that the individual doesn't want it to be communicated to, it can be an infringement of the right as well. The best South African act that we have when it comes to informatics, unfortunately, there's only one, is the Electronic Communications and Transactions Act. Now, it's a very wide act. It doesn't offer a lot of protection, but it does institute a few safeguards against the improper use of personal information and electronic and social media. There is currently a proposed bill on the protection of information in South Africa. It hasn't been enacted yet. Nonetheless, the ECT defines exactly what personal information is, and it includes information relating to the race, gender, pregnancy, and so on, etc. But what is important is Section 51 of the specific act. It states that if any individual, whether it's a state organ or an employer or just an individual person, wants to use someone's personal information, they can only obtain the information with the written permission of that specific individual. It may only be used for the specific lawful purpose for which it was collected, and may not be disclosed or divulged with any third parties unless that person is required to do so by law or permitted by the individual whose personal information this is. Any information that is gathered has to be available to the person whose personal information that is. In other words, if that information is incorrect or something has been altered or changed there, the person whose personal information that is must have an opportunity to change it or amend it or even delete it from the server of that specific person who collected it. Is posted information protected? What do you think? Do you think posted information is protected? No, not a chance. In the South African case of Cilliers versus Careflight, ladies and gentlemen, the court stated clearly that the information posted on social media sites are unprotected and can thus be used as evidence against an employee facing dismissal. It's a fact, ladies and gentlemen, that if you post something on a social media website, or really any electronic media platform for that regard, it is regarded as a public posting. It's a publication, which means that at the very least, well, today, a few million people can read what your status update is, or know what your name is, or know what your race is, or know what your ethnicity or sexual orientation is. What about information gained from telecommunication or internet service providers? Well, we in South Africa follow your provisions in this regard as well. Internet service providers or any sort of electronic service provider will only be liable for the use and access and the flow of any personal information if they exerted some sort of editorial control over it. If they didn't know what the content of the information was, they had no knowledge of it, they can't be held liable. All right, that doesn't sound great at the moment, but the Protection of Personal Information Bill in South Africa aims to change this a bit at a later stage. So if an ISP acted as a mere conduit or a hosting service or just a cache service for information, they can't be held liable for what happens to that information or where that information goes. So clearly, information obtained from a social media site should not be used during the appointment process in employment unless that information has a realistic bearing on the employment relationship itself and employees have access to that personal information. People lose their inhibitions online and say things they would not normally say, look at things they would not necessarily want others to know they were looking at, and reveal things about themselves that normally would be private. Disgruntled current and former employees have not been able to resist the temptation to leak the employer's confidential information online or misappropriate such information for themselves or for a future employer. So a big problem that exists for employers today is deciding whether to restrict, ban, or allow social and electronic media in the workplace. But wait a minute, why are we only focusing on what the employer has to do, what the problems with regards to the employer are? Why not focus on the duties of the employees? In terms of our common law, an employee has a bunch of duties that they have to comply with, amongst other things, to be subordinate to the employer, to maintain the bona fides, to exercise reasonable care when using the employer's property. Now, if an employee uses the electronic systems of the workplace in any way other than authorized, or accrues costs for the workplace, or opens the door for viruses or malicious code into the workplace systems, that can be seen as insubordination, which is a form of misconduct, which is a good reason for a dismissal, or rather a fair and valid reason for dismissal. So this will certainly breach one, if not all, of the employee's common law duties. Not to mention that if an employee makes himself guilty of a wrongful act in these online activities, there is the possibility that the employer can be held liable if it happens during the scope of employment through vicarious liability. So the question really is, can employers then monitor employees' communications and information on their work computers? Now, in terms of RICA, the controversial act, it states that all interceptions and monitoring of information is generally prohibited. There are few exceptions. I'm just going to name the first three, where the intercepting party is also a party to the communication. Now, this makes a lot of sense, seeing as how an employer owns the computer. It owns the system that the employee is using to communicate and infringe someone's rights or post any sort of information. So is the employer then not also a party to that specific communication? Is there then really an expectation of privacy on the part of employees when they use workplace computers? Where a party to communication has provided prior written consent to the interception, why not add a little clause in the employment contract that states, if we think that you're taking part in any wrongful activities online using the workplace systems for any unlawful activities, we have the right to intercept your communications and take a look at what's going on. The parties whose communications will be intercepted needs to be notified of the interception, and the interception itself must occur on a valid and reasonable basis, for a valid and reasonable reason in that regard. The Basic Conditions of Employment Act of South Africa states, ladies and gentlemen, that employees are free to discuss any matter related to their terms and conditions of employment, but nothing more than that. So it's more or less the same as Section 7 of the National Labor Relations Act that says that employees have the right to take part in concerted activities. But the question is, how far does the concerted activities go? How far do they go, rather? If an employee at the workplace posts something funny online about the employer that makes all of the other employees laugh, does that not improve working conditions? Or is that too wide? US case law seems to favor the opinion that employees do not have a reasonable expectation of privacy when it comes to electronic communications at work if they use the computer systems or the systems of the workplace. But they do have a right to privacy in their workplace computer, and I'll explain that specific statement by referring to South African case law in this regard. In Daniel Philip Neethling versus South African Fruit Terminals, an employer obtained information from a file of his employee on the employer's computer marked personal. And the Commission for Conciliation, Mediation, and Arbitration had to decide, well, is this information that he obtained from this file marked personal, can that be used during his dismissal or not? The employer wanted to use it. So the Commission, oddly enough, in this specific case found that no, you can't use that information because it infringes upon privacy. The Commissioner held employees were entitled to use their computers for personal purposes, and that the evidence obtained by invading the applicant's privacy must be disregarded. So, again, legislation and case law, to some certain extent, they clash with one another. One says this, the other says that. Nonetheless, the employer was aware of the fact that that file was marked personal, and that it probably had nothing to do with the employment relations or communications with clients of the employer. With regards to dismissal, ladies and gentlemen, posting comments about an employer on a website like Facebook that can be seen by an uncontrollable number of people is no longer a private matter, but a public comment. Like I said, it's being published. Millions of people can see what you're doing on Facebook, at least in terms of your status. A Facebook posting while initially undertaking outside working hours does not stop once work recommences. It remains on Facebook for anyone with permission to access the site to see. It would be foolish for employees to think that they may say as they wish on their Facebook page with total immunity from any consequences. When you use electronic media, when you use social media to say or post, do whatever you want to, you always leave a trail or a history. And it is this history, this trail, that can be used as evidence in litigation, at the very least, against employees. And I've cited American legislation and South African legislation at that point. So we're not that different, you and I. All right, in South Africa, though, the termination of an employment contract is a little bit difficult. Well, not difficult, a little bit more intricate. You have to comply with two specific requirements. The first being substantive fairness, which means that you have to have a valid and fair reason for dismissing someone. This can include misconduct. When an employee uses the workplace's electronic system in an unauthorized or illegal matter, that comes down to insubordination or misconduct, which means that there is a valid and fair reason for dismissing the employee. But misconduct, again, is not that simple. The Labor Relations Act states that you have to take 3 factors into consideration. It's actually 4, but first and foremost, the employee's awareness of the rule that was contravened. So, all right, obviously there's one requirement missing there. There has to be a rule that states you're not allowed to contravene, well, the specific rule. You're not supposed to do this. Was the employee aware of that specific rule? Was the rule reasonable? And was the rule consistently applied in the workplace? So if there is a rule and the employee does not comply with the rule, then that can come down to misconduct, or it can constitute misconduct, and that would be a valid reason for dismissing the employee. So is an electronic communications policy in this regard, can that be seen as a rule? Yes, it can be seen as a rule, but it's not necessarily the be-all and the end-all when it comes to a fair reason for dismissing someone for misconduct. In certain cases, the courts have accepted that, well, logic plays a role here as well. In the case of Warren Thomas Griffith versus VWSA, an employee used the workplace system to gain access to pornographic sites, and there was no electronic communications policy that banned this specific use of the workplace system, but the workplace policy that was in place said that the employees are not allowed to do anything undesirable when it comes to any system that's implemented in the workplace. It's very wide, but the court accepted that, look, use your logic in this regard. Obviously, the access to online pornographic sites would be undesirable, and it would incur costs for the workplace and for the employer. So, ladies and gentlemen, if you post defamatory or derogatory comments on a social media platform, whether you're doing it during working hours or after working hours, and I've cited American and South African case law in this regard, you can be dismissed, or at least a disciplinary hearing can follow that specific type of conduct. So in conclusion, ladies and gentlemen, what am I trying to say here? I humbly suggest, that employers and workplaces take the following steps alongside the implementation and the consistent application of a proper electronic and communications policy in the workplace. First and foremost, restrict access during working hours to only websites that have some sort of value or bearing on the workplace and the workplace activity. Now, this will give the employees a certain amount of leeway in terms of which they can go on any website they want to in terms of their lunch break. Well, not any website they want to, but social media websites at the very least. During their lunch break, before or after working hours. In this regard, there is software that can time restrict the access to certain websites during the day. Educate and train staff on how the use of electronic and social media can cause problems within the workplace. Tell them that, look, if you go on a sketchy type of website and you divulge your personal information, you're opening the door to malware, viruses, and possible identity theft. And any type of conduct that you make yourself guilty on that can disgrace the employer or the workplace will lead to disciplinary action and probably your dismissal. Emphasize the confidentiality obligations of employees that are hopefully in every employment contract that attorneys draft. I hope. If it's not, it should be there. All statements made to the media or via electronic media must be approved by the employer with regards to confidentiality. Set security and usage policies and have the employees sign these policies. It can be added to the employment contract. Why not? Have them sign these policies that clearly state what they are allowed to do and when they are allowed to go on certain websites, what they can do, what the employer's rights in this regard would be, as well as what the consequences would be on either side if any party should breach the provisions of that specific policy. Personal use can be permitted, but employers should always keep in mind that the employer will be able to monitor their online activity. It is, after all, the employer's system. It's the employer's workplace. They will have the right of access to all of these types of information and communications online. So, ladies and gentlemen, the above steps could satisfy the needs of the employer without leaving the employees feeling that their constitutional rights have been infringed upon and having them forced to defame the employer's name on Facebook or Twitter or any one of those accounts. So if the employer or if I can leave you with one specific message in this regard, and if the employer can leave these employees with one specific message in mind, it's basically, don't say anything online that you wouldn't want plastered on a billboard with your face on it. Thank you very much, ladies and gentlemen.